and to protect the public.
Rupert Lowe, are you on the right?
Thank you, Mr. Speaker. The jury trial has been embedded deeply into the British psyche and indeed into our Constitution, really since Henry II, who introduced the jury trial to fairly deal with land disputes. Indeed, it's embedded into the US Constitution through the Sixth Amendment, and it's embedded there to protect against biased judges, oppressive prosecutions, and it's there to safeguard individual liberties. I have severe doubts about our judiciary at the moment. I'm not sure they're going in the right direction. And when I read the adult court bench book, it gives me even greater concerns. The jury trial is already under threat, as you probably know, in defamation cases. So I have three questions. Why does the government appear to be so terrified of decent British people sitting on juries? Are the government intent on further undermining the jury trial? And if they are, in any way, will they please undertake to have a full debate in this House before it happens?
Minister.
Well, first of all, if you'd heard my earlier answers, I made clear that the jury trial will remain a cornerstone of British justice for the most serious cases. Sir Brian Leveson, in his review, talks about whether it's appropriate and proportionate to have a jury trial, for example, in some of the most complex fraud cases. He also considers whether it's proportionate in cases where, say, for example, someone steals a bottle of whiskey. Is it appropriate to have a full jury trial with all the cost, expense and delay, which means that somebody who perhaps is a victim of rape is waiting 2-3 years for their day in court and means that that day will never come. But what I can undertake, as I said in opening, is that when we are ready with our package of reforms and response to this review, we will return to this House and a full debate can be had.
Richard Hall.
Thank you very much indeed, Mr. Speaker. The jury system is essential to protect us against oppressive judges, malicious individuals, sometimes malicious police officers, or even governments. The Minister speaks of the most serious cases, but isn't it the case, actually, that the most serious impact on individuals can be not from necessarily what she may regard as the most serious cases, but any case which goes to court, because the impact on the individual can totally change the course of someone's life, even if the charge perhaps isn't as serious as she might consider it to be, because the impact it can have can be devastating on their family life, on their career, or all other aspects of a person's future.
Minister.
Well, as he knows, and as I said earlier, 90% of cases in this country already happen without a jury. No one says that that is not delivering justice of the highest robustness and integrity. And indeed, I'll pick him up on his comment, and indeed earlier comments, denigrating the integrity and independence of our judiciary. You won't hear that sort of criticism from this side of the House. No. Our judiciary is in fact one of the prides of this country. It's actually why people so respect the rule of law, why the UK is such a great place to do business. I won't talk the judiciary down. We need them, we respect them, and on this side of the House we'll adhere to that.
Richard Ford.
Thank you, Mr. Speaker. The Justice Secretary talks about the need to expedite trials for the sake of victims of crime, and she is absolutely right. As she considers these proposals from Sir Brian Leveson, will she also take into account those who are innocent, who stand wrongly accused and who are having to wait anxious years for their day in court?
Minister.
He makes a very, very good point, which is that whilst our focus is on victims of crime who are waiting, some cases, years for their day in court, on the other side of the coin, those defendants accused of a crime, perhaps wrongly, waiting to clear their name, that can have a devastating effect. It's really what he describes is the human impact of the delays that have accrued as a result of the backlogs which we inherited from the party opposite.
Well, calm.
Mr. Speaker, as a barrister working in criminal courts, I've often addressed the jury in closing speeches by saying, members of the jury, we have the best legal system in the world. And it's the best because you make it that. You bring your wisdom, you bring your life experiences, your common sense, and you apply it to the facts in this case. And before you decide a verdict of guilty, bear in mind that if you or a member of your family was sat in that box, in that defendant's seat, you would need to be sure before you return that verdict of guilty. Because as a peer, that's an obligation upon you. Now, I get the Minister's point that justice delayed is justice denied. But equally, Mr. Speaker, there is the principle of justice must not only be done, but it must be seen to be done. And where we have Sir Brian Livingston given a basic mandate that we need to speed up jury trials or get a result, that's just going to eliminate the very fundamental principles and cornerstone of our legal system. Does the Minister agree with that?
Yeah.
The jury trial, as I've said, will remain a cornerstone, a pillar of our justice system for the most serious cases. But what Sir Brian Leveson tells us in his report, in the opening pages, is that the current system is broken, and he uses the word essential. He says reform of the system will be essential because whilst we rightly take pride in the principles that underpin our criminal justice system, the fact is, at the moment, it simply is not working. It's letting down those whom it's intended to serve and those who serve within the system. We've got to fix that, and that's why we will take our time and then we will act on the programme of reforms that Sir Brian Leveson has recommended today.
Jim Allister.
Speaker, in Northern Ireland, for over 50 years, we have had judge-only trials in terrorist cases, probably for understandable reasons. All non-terrorist cases have been jury trials. In my professional life, at the bar, both the junior and the senior bar, I have practiced before all those courts. And the experience that that gives confirms to me very firmly the belief that public confidence is most attainable when we have jury trials. Irrespective of how cautious, of how diligent a judge is, judges can get case hardened. And that is the source of why public confidence rests most in the jury system. And therefore, would the Minister agree that the key determinant here in retaining jury trial is whether the offence is an indictable offence or not? And if it's an indictable offence, then the first port of call must be a jury trial.
Minister.
Well, I respect his wealth of experience before our different sorts of court, but I also respect the wealth of experience that Sir Brian Leveson